When I clicked on the screen, there were a whole bunch of new faces, so I'm not sure who everyone is, but I'm David Smith. I'm here on behalf of the appellant Linda Schaefer. I do appreciate the court taking the time and setting this for oral argument. And again, I appreciate being able to do this by Zoom. I know people down our way are still having to deal with internet problems from the hurricane, believe it or not. So I do appreciate it. This case is another old case, like you just heard. It's been around since 2009. We're here on a appeal of a summary judgment. In this case, it's another issue of standing, like the court's heard multiple times this morning already. But the facts here are a little bit different. My client did raise as an affirmative defense the issue of standing in 2009 in her original answer. The original note was filed 3 years later with the court in 2012. The original note is different in the endorsements than what was attached to the original complaint. Notably, the original note has the endorsement on the note voided, and then there is a subsequent allonge. So the note attached to the complaint had a blank endorsement, but the original had that endorsement voided and a subsequent allonge. Both the original endorsement and the subsequent allonge were signed by the originating lender, BankUnited FSB. In 2014, 5 years after the case was filed, an assignment of mortgage was entered in the case, or recorded in the public records. I'm not sure when it appeared in the case. But the assignment of mortgage suggests that the original lender, BankUnited FSB, was placed in a receivership with the FDIC in May, I believe, of 2009. And because all the assets were sold through that purchase and assumption agreement, the new lender, BankUnited, then obtained ownership in the note at some point. The issue that we had on the summary judgment, and consistent with my client's position since 2009, is that these documents, or in her case, the documents attached to the original complaint, didn't support standing. And because the original note and the assignment came along later in the case, we believe at summary judgment, the burden would be on the plaintiff to produce some type of evidentiary or testimonial explanation as to why the endorsements changed, the assignments came after the fact. And in this case, the affidavit before the court at summary judgment simply stated the original note attached to the complaint is, the affidavit states that the note attached to the complaint is the original. And then the affiant attached a copy of that to his affidavit, saying that our standing here on summary judgment is because plaintiff is owner and holder of the note. The problem is that note is not the original, and the endorsements are different. And that was the allegation. That was the testimony to support the motion for summary judgment. Now, counsel in their motion for summary judgment attached other things and made allegations of standing by way of the purchase and assumption agreement and the assignments, but there's no testimony or evidence to support those allegations. When the court ultimately entered judgment, the court based the judgment on assignment of mortgage and possession. The court was specific. Judge McHugh took her time and reviewed the evidence and the record, entered a judgment and explained her reasoning, consistent with the new federal standard, which this case does apply under. This came after the new standard was in place. So based upon that, we believe that there was error because there were genuine issues of material fact. We believe a reasonable jury could find in favor of the appellant in this case, because of the fact that the testimony and the evidence before the court was not consistent with the truth, which is the original note that had an endorsement voided and a subsequent allonge filed 3 years after the case was filed from the originating lender. What a reasonable jury could find is that the original.
What is the effect, though? As I I've had this had to outline this to be sure I had the scenario correct in my mind, but there was an assignment in dated September 22nd, 2014. And it confirmed the May 21st, 2009 transfer of the note and mortgage from FDIC to what I call the new Bank United in the purchase and assumption agreement. And that assignment was recorded in the public records. Didn't that document itself confirm that the new Bank United that filed this lawsuit owned the note and mortgage when it filed the foreclosure action in whatever it was, November 2009?
We surely don't dispute that it's evidence in favor of the plaintiff.
Isn't it? It's a document recorded in the public records. You know, and under the new summary judgment standard.
Yeah.
I mean, aren't we looking just for like genuine issues of material fact?
Right, exactly. And that's where we tried to make our point in our initial brief, that the genuine issues here being the note and the testimony.
Well, the note can be changed left and right in terms of whether the original was attached, but the question is not whether the original was attached to the complaint. The question is whether the plaintiff owned the note at the time it filed the suit.
Correct. And that's exactly what the problem that was presented here. So the affidavit attached to the motion for summary judgment specifically detailed their allegations of standing, saying we're the owner and holder of the note. This is the original. And those endorsements were not correct. They're simply not correct. The reason that I believe there's a genuine issue of material fact is the fact that the endorsement on the original note was made presumably at some point between when the case was filed and 2012. And that endorsement would have had to come from Bank United FSB. That would presumably, in the chronology that you just detailed, have come after the purchase and assumption agreement executed by the FDIC. So that conflict would create that genuine issue where they would need testimony, similar to the Stone case.
I'm sorry, you suggesting?
Yeah, I'm sorry, I think you were talking, but I couldn't hear you.
Yeah, I was muted. Sorry, do that all the time, at least once in every one of these things. So let me get this straight. Are you suggesting that a subsequent endorsement of a note that it no longer owned somehow undermined the validity of the purchase and assumption agreement?
Well, see, that's where I think the Stone case.
Frankly, that bank went away, as I gather, right?
That's the question. And in the Stone case, this court looked at, I think it was in 2013, it had a somewhat similar fact pattern, this Bank United FSB merger, Bank United kind of thing.
It wasn't a merger.
A receivership, yes, correct.
Went under. Its assets were taken and then sold to the new Bank United.
Yes, and in that Stone case, testimony was set forth by, I think it was Patricia Fallman, and she was the one that detailed for the court in that case, the trial court, about this whole process, saying, hey, I worked for Bank United FSB. I was there during this receivership portion. I then became an employee of Bank United. And in that Stone case, this court, looked at these issues. And that was the case cited by the appellee in this case. The problem is Stone can't provide authority here because the difference between this case and Stone was in Stone, they had that testimony from people working at Bank United before and after that can talk about these issues. Here we are absent any testimony, and without that testimony from the original entity that filed this case, we can't just accept a servicer's position how many years, 8 years, 10 years later, saying, hey, look, we're in possession of it now, although we have no recollection or knowledge of what happened back then. And that's where I think it's, McLean, where the courts are saying if the endorsements are different, you need to have some testimony from that original lender or the original plaintiff to authenticate or give us some kind of a clean line as to how the standing went. And that's what the court, I believe, needed to do here, was simply have an evidentiary hearing saying, this isn't right for summary judgment. This is a trial case. We need someone to come in here and explain to us why all these things happened after the fact. 3 years later on the note, different. 5 years later on the assignment, with none of those things even being brought forth in the affidavit attached to the motion for summary judgment. If they had attached an affidavit that detailed, this is what happened, we got ownership from the purchase and assumption agreement, the case would be 100% different. But they didn't do that. The affidavit was
the recorded purchase and the recorded assignment that harkens back to the purchase and assumption agreement is not sufficient record basis, you're saying?
I'm saying because they're conflicting evidence, their allegations and their testimony was, we don't have the right to be here. We haven't established standing by assignment. We have established standing by being the owner and holder of the note. And here's the note. And that's where I'm saying, if you're going to come in and on summary judgment and take a position as to this is how we're meeting our prima facie evidence of standing, since it was raised as a defense, they're bound to that. If they came in and they attested, just look at the assignment of mortgage, that's enough. That would be a different case. But they didn't. They hung their hat on the note that they then attested was incorrect, and that's what they based their standing on. And what we responded to was, this has been in the records for 9 years. We raised this issue 9 years ago, and you still, to this day, at summary judgment, are still hanging your hat on this note. And never, ever was it an assignment of mortgage standing case until now. So that's where we believe the court error. We believe it's an evidentiary issue. We believe there needs to be testimony about what happened 9 years ago, explain the voided endorsement, because surely somebody's taking a step to say that's wrong. It's incorrect. We're voiding it. And we believe that bring somebody in like you did in Stone. There's no reason that you shouldn't be able to do that, but that needs to be done to meet that evidentiary burden. Someone has to testify about these things that create what we believe are genuine issues. Thank you.
Okay, thank you, Mr. Smith. Ms. Bridges?
Yes, good morning, Your Honors. Jennifer Bridges on behalf of the appellee, Wilmington Savings Fund Society. May it please the court, this court and its sister courts have been very clear that there are alternative ways to establish standing to foreclose. And in fact, the appellant at least acknowledged that by citing in their initial brief to the Vogt versus Wells Fargo Bank case, in which this court explained that a plaintiff who is not the original lender may establish standing to foreclose a mortgage loan by submitting a note with a blank or special endorsement, an assignment of the note, or an affidavit otherwise proving the plaintiff's status as the holder of the note. So these are alternative methods by which standing can be established. And in our motion for summary judgment, we argued two alternatives. One alternative was based on the endorsement on the note, but the other alternative, and the alternative that the trial court accepted, was that there is a complete chain of title from the originator of the loan all the way through Wilmington. And that chain of title established that the original plaintiff had standing at inception and that our client obtained that standing at the time that judgment was entered. So you had there's no dispute here, Your Honor, that the old Bank United, as I'll refer to it just for simplicity's sake, failed, that the FDIC was appointed as receiver, and that on May the 21st of 2009, there was that purchase and assumption agreement that you referenced, George Northcutt, that transferred all of the old Bank United's assets to the newly formed Bank United. And it was that new Bank United that filed this case several months later on November of 2009. Because it already had possession, already had ownership of the instant note and mortgage, it had standing at inception of this case. And then the 2014 assignment that was recorded later on did nothing more than to provide public notice that that transfer had occurred. That document in and of itself did not effectuate the transfer. The transfer already happened.
That document created a public chain for purposes of the next assignment that was executed right about the same time, correct?
That is correct, Your Honor, because
Public
immediately
chain of ownership at that point.
Yes, Your Honor, exactly. So immediately after that was recorded, there was a second assignment that was recorded from the new Bank United to an entity called Pretium, and then a third assignment immediately after that from Pretium to Wilmington. And those assignments, the second and third assignment, made it clear that both the note and the mortgage were being transferred. And so there is a complete chain from the originator to new Bank United to Pretium to Wilmington. And we only have to establish that, Your Honors, in order to demonstrate standing. I will note that we asked for judicial notice of the purchase and assumption agreement, which is a publicly available document on the FDIC's website. We also asked for judicial notice of all of the assignments. Ms. Schaefer did not raise any kind of evidentiary objection to that below. She did not raise any kind of evidentiary objection at all, in fact, in response to our motion for summary judgment, but instead focused on the endorsement, on the note, the timing of the allonge, and whether or not the 2014 assignment was effective to convey the note and mortgage. And respectfully, we believe that those arguments, at least the arguments regarding the note and mortgage, are red herrings, because that's not what the trial court based its summary judgment ruling on. It based it on the chain of title evidence. And this court noted as well, I'm glad that Stone came up, Your Honors, because Stone, I think, is instructive here. In that case, there was an issue regarding the allonge, and the court held that that issue carried no weight in light of the purchase and assumption agreement. Now, appellant would like to distinguish Stone because in that case, it went to trial. There was a witness that testified as to Bank United's servicing, but again, there was not an evidentiary issue here. There was no objection to the court taking judicial notice of the purchase and assumption agreement, and there was no need for us to present a witness to authenticate that document or explain it. The trial court could read the document for itself and determine what its effect was. Essentially, Your Honors, we believe that this is a pretty straightforward case in which standing was clearly established through this alternative means of chain of title. I would note as well that as far as the effect of the purchase and assumption agreement, or whether it's material evidence, Ms. Schaefer did not raise any such arguments below. I know that that was raised in the reply brief, but those were not addressed below, and those have been waived. And we would ask the court to affirm the entry of summary judgment. I'm happy to answer any questions that the court may have.
I have none.
Okay, Mr. Smith, you didn't let me know how much time you wanted for rebuttal, but you're down to about 6.5 minutes. So
Okay, I was going to ask that the issue with the purchase and assumption agreement, the reason it wasn't raised is because it wasn't presented. It's interesting because in the finding of the court made no mention of the purchase and assumption agreement. And in the affidavit attached to the motion for summary judgment, they made no mention of the purchase and assumption agreement. And in the complaint, they made no mention of the purchase and assumption agreement. But that seems to be the central issue here, although from our perspective, it's simply irrelevant. If you make your allegations and you support them with affidavit, that's what's before the court. The court could do, under the summary judgment standard, can dig through the record, of course, and find its own basis. But that's not what the court did. The court was very clear in what the court found supported standing. And it said assignments and possession. The court made no mention whatsoever of a purchase and assumption agreement. If the court did find that that supported standing, presumably it would have said so, and we wouldn't probably be here on appeal. But it didn't. The court says possession, not assignments or possession or just assignments, but assignments and possession. And that's why we focused our opposition and motion for summary judgment and this appeal on possession. The possession evidence before the court was simply not true. It's not that it was, mistaken or an error or a scrivener's. It was blatantly untrue. The note attached to the complaint was not the original, not even close. There were subsequent allonges, voided endorsements. This isn't a case where it was not photocopied on the back and things, we've dealt with over a decade. This is simply a different note. And that's the evidence that the appellee here brought to the court to say, Judge, look at this. This is what we're establishing as standing. And that's what the court ruled on. The court ruled on the untrue evidence. And that's where we're saying that simply cannot meet the summary judgment standard. A reasonable jury surely could rule in favor of Ms. Schaefer here, because you would say, wait a minute, your allegations and your evidentiary support for your motion for summary judgment are based upon this document, this note. And the note you're presenting to the court is not true. It's not truthful. Could a jury find, in her favor? Absolutely. Because the endorsement on the original note came after the fact. And if the endorsement came after the fact by a different party that's filing this case, the easy assumption is then that party was the one was standing at the time the case was filed. If they're endorsing notes 3 years later, surely they had standing. And so that's where the genuine issue comes from. The purchase and assumption agreement, like I've said before, is irrelevant because it had no bearing on the court's decision, the pleadings, the allegations, or the motion for summary judgment testimony.
Do you think it might have bearing if we were to reverse and send this back for further proceedings?
I'm sure they would bring it. I'm sure they would bring a witness in at trial and talk about it based upon what we're hearing today. Right?
They need a witness if they had certified copies of the recorded documents.
I don't disagree that the document exists. I don't disagree they could produce certified copies. I'm sure they're readily available. But I still believe, because of what they pled, there's been no amendment to their complaint that their basis for standing is anything other than holder of the note. And so could potentially they obtain a judgment? Well, yeah, I mean, I'm a lawyer, right? Everything's possible. But on the facts before the court now, I think a reasonable jury could find the other way. And that's where we're arguing that summary judgment's improper. We're not arguing dismissal. We're not saying, this was a trial and the court improperly entered final judgment. What we're saying is summary judgment's improper. Thank you.
Yeah. Thank you both very much. You want to leave this virtual space, and the way you do that is you click